morning, everyone, and thank you for joining us for the next webinar in our Charities Bite-Size series. My name is Kate Harris, and I'm a Senior Associate in Burkitt's Contentious Trusts and Probate team. And today I'm going to be speaking to you about disputed legacies from a charities perspective, and specifically looking at how a charity should proceed when it finds itself caught up in the middle of a probate dispute. Now, we're incredibly lucky at Burkitt's to have an excellent charities team, which is headed up by Liz Brownsell, who many of you may know. And we work very closely with them to advise our charity clients in relation to disputed legacies and to help those charities make informed decisions as to how best to use their resources to protect any legacies that they may have. Now, there will be time for some questions, hopefully, at the end. So if you'd like to submit any questions that you might have into the chat box, I will do my best to answer them after my presentation. And I should also say that there will be a copy of the slides available following the webinar, which will be sent out in the next week or so. So, just getting started. So legacy disputes, it's a very topical subject, especially following the pandemic, as studies actually show that COVID-19 had a significant financial impact on the charity sector, with charities experiencing a loss of income, understandably, as a result of mass participation events not taking place and high street charity shops being closed to the public. So unsurprisingly, this has resulted in an increasing pressure on legacies, which make up a sizable part of many charities' income. In fact, the figures show that the pandemic has now had a positive effect on charitable intent, and that the UK public are making more charitable gifts in their wills. So the levels of income which charities are receiving from legacies is continuing to increase year on year, and legacy income has actually risen by almost 13% over the last 12 months. A recent report from Legacy Foresight shows that charities in their benchmarking programme, which account for around half of the UK legacy market, received £1.62 billion worth of cash legacy income in 2021, and that's compared to just £1.44 billion worth in 2020. So, and this figure is expected to increase significantly over the next 5 years, with between 134,000 and 137,000 charitable bequests forecast to be made each year. So while this is obviously really great news for charities, it will inevitably bring with it a growing number of disputed or challenged legacies. And again, current figures show that roughly 1/3 of charitable legacies are subject to some form of dispute. So this means that it's more important than ever for charities to understand and appreciate the factors that are at play in a disputed legacy situation. And the aim of our webinar today is to provide an oversight of legacy disputes and to give you some practical pointers on how charities should approach them. So if we start with some key charity law duties, which are going to underpin any and indeed all decisions that are taken by a charity when faced with a legacy dispute. Now, these duties are likely to be familiar to all of you on this webinar who practice in the charity field, as they apply equally to other aspects of charity management. So running through them, firstly, and perhaps obviously, there is an overriding duty on trustees to act in the best interests of the charity, and this is both in the short term and the long term. And that duty extends to furthering the charity's purposes. So in order to do this, the trustees need to consider the core values of the charity and its general mission statement. And they also need to consider the importance of safeguarding the charity's reputation, but also protecting the interests of the beneficiaries of the charity as a whole. And we're going to come back to how these two factors sit alongside each other later on in the webinar. So secondly, the trustees also have a duty to collect and preserve charity assets, which extends to recovering charity assets. And in the context of what we're talking about today, a charity asset will include a legacy which has been pledged to the charity under a will, even if that legacy has not yet been paid out. Thirdly, there's a duty on trustees to act with reasonable care and skill. And this will mean that trustees must ensure that they seek and consider external expert advice so that they can be sure that they have sufficient information to properly understand the charity's position within the context of a legacy dispute and how best to approach that claim and potential litigation. And then fourthly, the trustees will also have a duty of prudence, and this requires them to assess the overall risk to the charity of engaging in any form of litigation. And this duty also extends to ensuring that the charity's resources are properly managed and that the trustees are acting reasonably so as not to expose the charity and its beneficiaries to any undue risk. And as I touched on above, this is also going to include considering any risk to the overall reputation of the charity. So those are just some key duties to highlight. Sorry, moving on to the next slide. So turning now to the types of legacy disputes which a charity is likely to face, I expect that many, if not indeed not all of you, will be familiar with these in a kind of broad way, but just by way of reminder, they are. So firstly, a claim to dispute the validity of a will under which a charity stands to benefit. Now, this is what we frequently refer to as an all or nothing claim, as in the event that the validity of a will is decided by the court, the outcome will either be that the will is valid or that it is not. So, in other words, there are no half measures. And so a challenge to the validity of a will may result in the charity receiving nothing from the estate if the claim is successful and there is no legacy to the charity in an earlier valid will, or if there is no earlier valid will, if the estate falls to be dealt with under an intestacy. Secondly, a charity may face a claim against the estate for reasonable financial provision under the Inheritance Provision for Family Independence Act 1975. And that claim is going to be likely made by a family member or someone who claims to have been maintained by the deceased before they died. Now, this sort of claim could result in the charity's legacy being reduced or possibly eradicated, depending on the strength of the provision claim. And some of you will no doubt be aware of the Supreme Court authority of Islet and Blue Cross, which was a very highly publicised case involving an estranged daughter who made a claim for reasonable financial provision against her mother's estate, where the mother's will left her entire estate to various charities. Now, although the claim was partially successful, with the daughter receiving a modest award from the estate, the Supreme Court recognised the importance of testamentary bequests to charities in their judgment. And the court also made it very clear that the fact that a testator chose to leave a legacy to a charity in their will would not be disregarded. And these are some very welcome comments. It was a welcome development to charities, as the Court of Appeal in the same case had considered that the charities were not prejudiced by the daughter's claim, as they didn't have needs in the same way that an individual claimant or defendant would under the 1975 Act. So that was encouraging. But although the Islet case did confirm, as I say, that the court should not simply ignore charity defendants to a 1975 Act claim, it does still, I'm afraid, remain the case that a charity defendant will be in the same position as any other defendant to a provision claim, and so the court will weigh its position against the other beneficiaries by taking into consideration all of the factors under Section 3 of the Act, which will include financial needs and resources. Again, I'm going to come back to this later on and discuss that in a bit more detail about how a charity can practically manage that issue. And so thirdly, the other most common type of claim which a charity is likely to face is one in relation to the rectification or construction of the will. And these types of claim will typically arise where there's been a mistake in the drafting of the will, or the wording or meaning of the will is not clear. And so in either scenario, the end result could be that a legacy to a charity falls away. So as we touched briefly on already, if a claim does arise, then charitable trustees need to be very careful in managing their approach to litigation. And not surprisingly, one of the primary considerations for the trustees will be the potential cost exposure to the charity of the litigation. The average legacy gift is now said to be in the region of around £63,000, and it's therefore quite possible that legal fees alone incurred in defending a claim could well exceed the size of a legacy of that amount. So in those circumstances, you can see that the need to very carefully manage the cost risk to the charity is going to be particularly important. However, even if a legacy is for a much larger sum, in the context of a very big estate, the charity is still going to need to consider the costs involved and to undertake a cost risk analysis at a very early stage. And that's all encompassed in those key charity law duties that we spoke about earlier. And in carrying out that costs analysis exercise, the trustees are going to need to consider not just the legal costs that they will have to pay their solicitor and or their barrister, but also the internal management costs that they're going to incur dealing with the litigation. Now, jumping ahead. There we go. In 2016, the Charity Commission published some new guidance for charity trustees who are faced with a litigation situation. This guidance updated an earlier document from 2010 and actually represented a shift away from that 2010 document, which focused on the risk of reputational damage to a charity that could be caused by embarking upon litigation. So although the Commission now recognises that reputation is still a very important consideration for charities, the updated 2016 guidance reflects their view that too much emphasis on reputational risk could actually force charities to settle claims even when they have very little merit. And the Commission now acknowledged that placing too much emphasis on reputation could in fact conflict with the other charitable duties of the trustees. So this means that the Charity Commission have adapted their approach, and the message from them now is that the charity's best interest should really be put at the centre of matters, and that trustees should only be going down the route of formal court proceedings once all other avenues have been explored, including mediation and other forms of alternative dispute resolution. So in order to put the Charity Commission's guidance into practice, charity trustees must, with the help of their legal advisors, very carefully consider the prospects of a claim succeeding or indeed failing. So if a claim is very weak, then the charity will have a duty, going to have a higher duty to defend that claim and to protect the assets of the charity, which, as I mentioned before, are going to include a legacy, which under a will. However, trustees, this doesn't mean that trustees are committing the charity to a full-blown trial. So as I mentioned above, there are various options available to trustees to avoid formal court proceedings and to try and reach a settlement early on in the claim. And in fact, the vast majority of claims are capable of being resolved either at mediation or through an exchange of without prejudice correspondence. And certainly in my experience, it's in fact very rare for disputed legacy matters to end up in a final hearing before a judge. So the potential to reach an early settlement is significant. So leading on from that, one of the primary considerations for the charity trustees is going to be the value of the legacy itself. And so what is at stake for the charity if that legacy is lost? And as I mentioned, an early cost-benefit analysis is therefore crucial. So in carrying out that task, the charity will need to weigh up the costs which are likely to be incurred in connection with the litigation. And they're going to have to balance those against the potential loss to the charity if the claim is successful and the legacy falls away or is reduced, depending on the type of claim they are facing. The trustees also need to take into account the fact that if the claim is successful, the claimant will no doubt be looking for an order from the court that their costs are paid by the unsuccessful party, which may, depending on the approach which is adopted in the litigation, include the charity. So the potential liability to pay the claimant's costs, as well as any irrecoverable costs of the charity itself, are therefore both factors which the trustees need to weigh up in the balance when undertaking that costs analysis. So just by way of practical example, in a recent case we dealt with, the charity in question was named as the residuary beneficiary and stood to receive the vast majority of an estate which was worth several £1,000,000. So there was a sizable legacy due to be coming to the charity. A claim was made against the estate under the 1975 Act by someone who claimed to have been maintained by the deceased prior to her death. Claim was worth in the region of around £500,000, and the cost of the charity of defending it to trial was likely to be in the region of between £100,000 to £150,000. An assessment by the charity of the 1975 Act claim was, in fact, that it was weak, as at least some of the payments which the claimant had received from the deceased were made at a time when her capacity was in question. And there was therefore some doubt as to whether the deceased had, in fact, assumed any responsibility for the claimant's maintenance at all. Excuse me. So the assessment of merits in this case was an important consideration for the charity, as if the claim was unsuccessful at trial, the charity would be able to recover a proportion of its costs from the claimant, and that needed to be taken into account when assessing the charity's potential exposure. So in this case, an offer was actually made by the charity of a sum which was lower than the cost likely to be incurred in defending the claim all the way to trial, on the basis that this represented a potential cost saving to the charity. The offer was also designed to put pressure on the claimant, who the charity said faced a significant litigation risk if she elected to pursue her claim. So fortunately in this case, the claim was settled on the basis of the offer, which meant that although the charity did have to forego a proportion of its entitlement to the estate, the sum the claimant received was in fact less than the charity would have spent to trial and less than the original sum claimed. Charity was also protected from the risk of being ordered to pay the claimant's costs had her claim ultimately been successful. Now, in that same case, the charity was also faced with a professional executor who was proposing to pursue recovery of sums, which had been paid out by the claimant's daughter during the deceased's lifetime and during the period when the deceased capacity was in question. So again, this was a case where the charity trustees had a duty to consider whether the cost of the executor pursuing this issue was ultimately going to benefit the charity, who were, as I mentioned, the residuary beneficiary. Now, as many of you, I'm sure, will be aware, the executor owes a duty to the charity to act reasonably in these circumstances. And in fact, given the likely disproportionate cost to the estate of seeking recovery of the lifetime payments, the charity's position was that the executor shouldn't pursue them. And that's just, although not strictly a legacy dispute, that's another example of the cost analysis which trustees of a charity may be faced with in the context of a disputed estate. And that case also highlights the approach which a charity should be taking in a disputed legacy situation, which is, as I said, to try and settle a claim where at all possible. That said, charities shouldn't be afraid to assert their rights to legacies, as they are an incredibly valuable source of income. But this just shows that it's perfectly possible for a dispute to be managed in a way which limits costs while ensuring that a charity's position is protected. And that again is going to make sure that the trustees are acting in the best interests of the charity. So it's all very well and good, jumped ahead, talking about trustee duties and the matters which trustees should be taking into account in the context of a legacy dispute. What I thought would be helpful would also be to run through some very practical steps which charity trustees should be taking when a claim does arise. So firstly, gather together as much information as possible about why the testator chose to make provision for the charity. And this is going to include any evidence to show the testator's connection with the charity during their lifetime, such as an established pattern of lifetime giving or other active involvement with the charity's work. So while this evidence is not necessarily going to be enough to defeat a claim, the claimant's job is going to be harder if the charity is able to show a strong lifetime link with the testator and to clearly demonstrate the reasons why the testator wanted to leave a charitable legacy in their will. Secondly, charity should be ready to demonstrate why the legacy is important and what charitable projects it will help to complete. This is going to be particularly relevant where a claim for reasonable financial provision is being made against the estate. Because as I mentioned earlier, where this sort of claim arises, the court is going to take all the Section 3 factors into account, including the needs and resources of the beneficiaries. Now, the needs and resources of the claimant are obviously going to be a magnetic factor for the court, but the court needs to balance these against the competing needs of the other beneficiaries and decide whose need is greater, who the deceased had an obligation to provide for, and who may have felt an expectation to benefit from the estate. So as I touched on earlier, a charity is going to be in a much more difficult position when it comes to showing needs than an individual claimant. But nonetheless, it will be helpful for a charity to set out how the funds it is due to receive will be used and how they are going to benefit the charitable objects. And just following on from that, the trustee, if formal proceedings are issued, the trustees should consider whether the charity should in fact file a neutral defence to the claim, which asserts the intentions of the testator in relation to the legacy and sets out, as I mentioned above, how those funds would be used, and then to propose mediation at a very early stage. And this is going to offer the charity cost protection and should hopefully help achieve an early resolution to the claim. The other point to consider is that if a mediation can be arranged, then that's going to take place on a without prejudice basis, which is going to provide scope for negotiations to take place. So, fourthly, if there are other charities involved in the dispute, steps should be taken to try and agree a unified approach with those charity beneficiaries and to perhaps nominate a lead charity, which is going to keep costs down and avoid any unnecessary duplication. Trustees should be documenting all decisions taken by the charity, together with the reasons for those decisions, in the form of trustee resolutions. And this is just going to help protect the position of the trustees in the event that any of their decisions are called into question at a later date. And then finally, trustees should consider whether the new powers under the Charities Act 2022, which are expected to come into force in autumn 2022, and which allow charities to make ex gratia payments up to a certain level without Charity Commission approval, could be used to reach an agreement with a disgruntled beneficiary at minimal cost and with minimal exposure for the charity. I think that topic is probably the subject of another webinar. It's quite extensive, but it's just something that trustees should, I think, at the very least consider in this context. So I hope that those points have been useful, and those the bits I've gone over, just to provide an oversight of disputed legacies from a charity perspective. And so now, if I just have a look at the questions that we've had in, we've had a few, so I'll just try and pick out the ones which I can answer now, and then any others I can address offline and come back to you directly. So first one we've had is, what about a case where the deceased has made it very clear during their lifetime that they want a charity to benefit, but a claim is then made under the 1975 Act for provision from the estate? Yeah, so that's a good question, and unfortunately, I think the reality is that the case law does show us that the courts have to date anyway shown very little inclination, shall I say, to favour the needs of a charity over an individual applicant, even in a case when the deceased might have shown a very fixed intention to benefit the charity. There is a reported case, the name of which I can't immediately remember, but it involves the University of Cambridge, where the deceased had left a letter of wishes in which he set out very clearly why he actually didn't want his wife to benefit from his estate. And during his lifetime, the deceased had entered into quite a sizable body of correspondence with the university, explaining the exact purpose for which he wanted the legacy he intended to leave under his will to be used for the university's charitable purposes. So there's quite a substantial amount of evidence in that case showing what the testator wanted, why he wanted the charity to benefit from his estate. But the court was faced with a spousal 1975 Act, which, as many of you will know, is judged on the higher standard of provision. So it's not limited to needs, and a spouse is considered as generally having a priority in that situation. So I think in that case, the court actually held that the needs of the wife were paramount, notwithstanding the very, very real, I think, expectation of the charity to inherit from the estate. And I think that case, and there are a number of others, I think the message from the court remains very clear that charities will not be given precedence over family members and dependents, albeit that some comfort can be taken from the case I mentioned earlier, the Islet and Blue Cross case, and the fact that the balancing exercise under Section 3 is still going to be carried out, even if the only other beneficiaries are charities. I suppose another point to mention is that, of course, if a 1975 Act claim is made, then the charity may look to reach a settlement with the claimant, which preserves the charity's entitlement for the future, but which makes short-term provision for the claimant during their lifetime. And one of the advantages of mediation or without prejudice negotiations generally are that they offer a very valuable opportunity to be creative and to explore inventive ways of settling a claim against an estate, which you wouldn't necessarily get if the matter goes all the way to trial. So that's, again, just something for trustees to bear in mind. Let's look at the questions. Okay, so I think I've got time for one more. So, someone's asked, so can a charity be a claimant as well as a defendant in relation to a disputed estate? Yeah, I think the very short answer to that is yes. There's absolutely no reason why a charity shouldn't advance a claim against an estate. But again, trustees need to make sure that they're complying with all of the duties we've touched upon today. So in the event a charity is electing to pursue a claim, it will be incredibly important for the trustees to take legal advice on the merits of the potential claim at an early stage, and then to consider the prospects of the claim succeeding. And that's going to remain a really key consideration, as in all cases, at all points throughout the litigation. So especially if and when more information comes to light as the claim develops. So I suppose the answer is essentially the trustees just need to bear those charitable duties in mind at all times to make sure that they are always hitting that need to keep the charity's best interests in mind. Okay, so looking at the clock, I think that's probably all we've got time for today. So thank you very much for coming. Just like to say that we do have the next webinar in our bite-size series, which is going to take place on 13th of July, and which is going to be looking at the key considerations for charity when disposing of charity property. So it's going to be the first of our charity webinars focusing on property issues. So I hope that you or your colleagues will be able to join us and look out for the registration link for that. Can I also say that there should be a survey on your screen, and we'd be incredibly grateful if you just had a couple of minutes to fill that out and submit it so that we can see your feedback and know what to do differently or what we've done well in this webinar. And so finally, it just leaves me to say thank you very much for attending, and hope you all enjoy the rest of your day and go and enjoy the sunshine. So thank you very much.